If you have a custody battle going on and you cannot reach agreement with the other parent to your children, then the court's going to have to do something about it. While divorce itself can be an emotional whirlwind, the intricacies of child custody evaluations can add a layer of complexity and stress and fear that often catches many by surprise. But don't worry, because I'm going to take that stress away from you in the next few minutes, so hang on, okay? So in Georgia, the court may appoint either a guardian ad litem or a custody evaluator to navigate the maze of your family dynamics. Picture them as neutral observers getting to know you and your kids so that they can make a determination and a recommendation to the court about what's truly in the best interest of your kids. So what's the difference between a guardian ad litem and a custody evaluator? Well, the guardian ad litem is typically an attorney representing the child's best interest, while a custody evaluator typically comes from a mental health background. Now, both of these people dive into the essence of your family dynamics, but their approaches differ. The guardian ad litem may focus more on the legal aspects of your case, while custody evaluators look into the psychological nuances of your family life. So you're probably wondering, why does somebody need to poke around in my personal life or the life of my kids? And here's your answer. If you have a custody battle going on and you cannot reach agreement with the other parent to your children, then the court's going to have to do something about it. But the judge is not going to make decisions on your child's future just based on a day or two in court without having met your kids or having had a chance to find out more about each parent's financial and mental situation, their home environment, etc. So the judge can't get off the bench and into your lives, but what the judge can do is appoint a guardian ad litem to do that and report back to the court with their recommendations. And what the judge can do is appoint a child custody evaluator to learn more about the mental health of the parents and the kids and report back to the court. So what's the reason for all of this? It boils down to ensuring that the court makes well-informed decisions that are in the best interest of the children involved. These evaluations by the guardian or the custody evaluator serve as a magnifying glass, helping to identify the strengths and weaknesses of each parent and providing a comprehensive overview of your family dynamics, including your interactions with each other as well as the kids. So I want to reassure you of something. The custody evaluation process is not about putting you on trial, okay? It's an opportunity for you to share your side of the story authentically. There's no cross-examination, you're not testifying, no one's going to be interrupting you as you speak. When you meet with the custody evaluator or the guardian ad litem, just be yourself, just be honest, and remember their goal is to understand your family dynamics and you, not to pass judgment. What the court wants them to do, through discussion with you as well as through their observation, is to examine each parent's ability to provide a stable home environment for your kids, evaluate your willingness to encourage a relationship between the children and their other parent, and, if your kids are old enough, to learn more about the children's own preferences. Now, the evaluators may also interview other people involved in the children's lives, such as relatives, coaches, other adults they spend a lot of time with, etc. So here's a shocker in this process. These evaluations are not foolproof. They cannot predict the future or uncover every possible hidden aspect or dynamic. The evaluator's recommendations are just that, they're just recommendations. When the final decision is made, the court considers these recommendations alongside other evidence also presented during the divorce proceedings. That's why it's critical to have a seasoned and experienced attorney throughout this entire process. So by now you're looking for me to tell you how you can prepare yourself for the unpredictability of a child custody evaluation in Georgia, right? Okay, hang out, here we go. First, just be yourself. The evaluator isn't looking for perfection. They want to witness the real you and understand how you react with your kids. Next, create a stable and positive environment for your kids. Consistency is so key, so maintain routines and prioritize the kids' well-being. Show your commitment to fostering a healthy relationship between you, your children, and their other parent. Show up for everything that you possibly can. Create the memories with your kids and capture them in photos and videos that show your involvement and show your kids having fun with you. Remember that communication is super important, so open up to the evaluator or the guardian ad litem. Discuss your concerns and share any challenges you may be facing. They're here to help, they're not here to judge. And through the entire process, just be sure to lean in on your attorney for guidance. We've been through this process many times, and we can guide you through it as well. Be sure to maintain your composure. Yeah, I know divorce and custody battles are stressful, but staying calm during the evaluation process, whether it's a custody evaluation, whether your situation is being evaluated by a guardian ad litem, makes a huge difference. Keep your focus on what's best for your kids and trust that the process is designed to ensure their well-being. After the custody evaluation process or the guardian ad litem investigation is over, Their recommendations will be shared with you and the other parent, and then you and your attorney have the opportunity to review the recommendations and hopefully engage in dialogue with the other side to try and reach a settlement on child custody without having to go to court and turning it over to a judge to do it. Maybe you'll go to mediation if you haven't already done so, or perhaps you'll agree to mediate again now that you have the guardian ad litem or the custody evaluator's recommendation. You've got a third party who's going to advise the court if you do go to trial, so maybe the best thing to do is meet with the other side and let's just get this thing resolved before going to trial. Maybe now all the grandstanding and stubbornness will give way to some serious practical negotiation when you both decide that you want to determine yours and your kids' fates rather than having a judge do it. This is a really common result of the guardian ad litem or custody evaluation process, and it's always my advice for clients: don't put your kids' ultimate futures in the hands of the court. Let me tell you something, judges hate making these decisions. I know, that sounds crazy, right? They're judges, they're supposed to be making decisions, but they don't want to be making decisions on your kids' lives, and they would much prefer that the parents do it with the guidance of their attorneys and with the recommendations from the guardian ad litem or the custody evaluator. Hey, thanks for watching this video. Be sure to click subscribe, like, follow, and turn on the alerts so that you'll get notified when we post our newest videos. Please share these videos and leave us some comments, ask us questions, tell us what other topics you'd like for me to talk about. Join our Facebook group at Georgia Divorce and Custody for more info. And as always, I look forward to seeing you on the next video.